Great. Welcome back to House Healthcare. We are now switching to S47, which we started last week, and we will start with a walkthrough. So we're looking at draft 1.1, which is on the committee page. Katie's going to do a quick walkthrough for us, and then we'll switch to some testimony.
Okay. Hello, Katie McLean, Office of Legislative Counsel. Okay, so we have oh no, we don't. I just pulled this off the website.
That's not the right one.
Yep. We will have a new amendment to look at once I pull it up.
But it's not on our website yet.
It is.
It is. I pulled up the as passed version. Okay.
Today's date.
Yep. Today's date. Take two. Let's see if I can share it now.
Yeah, it's on this one.
Okay. Okay. So here is the amendment. As you remember, this bill pertains to the transportation of individuals who are in temporary custody, and later on the second section looks at people who are in the custody of the Commissioner of Mental Health and how transportation of those individuals should be conducted. We've already done a walkthrough of the bill as introduced, and you've heard some testimony, and there are changes since the last time you've looked at this. So this is a strike all amendment with the changes highlighted. The rewrite would read that the law officer may take a person into temporary custody, and the law enforcement officer or the mental health professional shall apply to the court for a warrant without delay while the person is in temporary custody. Once application to the court for the warrant has been made, the law enforcement officer or mental health professional, if clinically appropriate, may transport the person to a hospital, police barracks, or another safe location. And then in subdivision 2, transports conducted pursuant to this subsection shall provide individuals with the same protections as provided to individuals in the custody of the commissioner who are transported pursuant to 7511. That's section 2 of the bill. And then in subsection D, we now have a D1 and D2, similar language in D2. D1 reads that if necessary, the court may order the law enforcement officer to transport the person to a hospital for an evaluation by a licensed physician to determine if the person should be certified for an emergency examination. And in 2, transports conducted pursuant to this subsection shall provide individuals with the same protections as provided to individuals in the custody of the commissioner who are transported pursuant to 7511. And then in the second section of the bill, this is 7511 that we keep referencing to. We have changes since the last time the committee has seen it. Oh, we don't. But the change in the bill directs a law enforcement vehicle to have soft restraints available as the first option, and mechanical restraints shall not be used to substitute soft restraints if the soft restraints are available and deemed adequate for ensuring safety. And the act takes effect July 1, 2023.
Great. So these are just suggested changes. We'll keep taking testimony and hearing from people. Any questions on this before we move on?
I missed where the changes were from or who had reviewed it.
Vermont Care Partners requested the changes.
Thank you.
All right. I'm sorry, go ahead. You want to clarify that?
Vermont Care Partners. DMH had actually been concerned about the language because they were worried that it broadened the scope of the commissioner of DMH. So these are kind of like technical edits to make sure that the same protections are applied when a person's in the custody of the commissioner and when a person's not in the custody of the commissioner. So it's kind of a language cleanup based on compared to what the language used to look like.
Thank you.
And also wanted to make DMH also wanted to make sure that the warrant was applied, like the sequence of the language meant that it's clear that if a person was taken into temporary custody, then the warrant was applied for and then the transport.
That's helpful. Yeah.
Thank you, Katie. Hi, Jack. So we have with us Jack McCullough, Director of Mental Health Law Project, Vermont Legal Aid. And Jack, I don't think we've had you in here this year yet, so welcome.
No, thank you, Madam Chair, members of the committee. Good to see you all. I was just thinking that it's been probably a couple of years since I've been in this committee, and there are plenty of people in this, members of this committee who don't know me, so I'll
Yeah,
give a little bit of an introduction.
please.
Although I was just mentioning this morning that when I first met Representative McFawn, when we were playing in the state employees softball league, probably 30 years ago.
That's a long time ago, Jack.
Yeah, a long time ago. But I'm a lawyer at Vermont Legal Aid, and since about 1994, I've been the director of our mental health law project. And we have a contract with the state to represent everybody in the state who's facing involuntary mental health proceedings. So whether it's someone in the community, someone who's in the process of involuntary hospitalization, involuntary medication, or now that we're doing criminal cases, someone who's been found incompetent to stand trial or not guilty by reason of insanity, and there's now effort made to involuntarily commit them. We represent all of those people across the entire state. This bill relates to a very particular part of the statute, 18 VSA section 7505. And this is one of two ways that someone can be involuntarily admitted to the hospital before an application for involuntary treatment, which is our name for a petition to commit somebody. Most people are in the hospital when the commitment case is filed in family court, and this is one of the two mechanisms to get people into the hospital. And what's special about this provision of law is that it applies when it's not possible to get a licensed physician to certify that the person needs to be admitted without unreasonable delay. And so the alternative is for the applicant to go to the judge and say, Judge, here are the facts that make us think this person needs to be involuntarily hospitalized, and we would like you to sign this warrant to allow us to take the person into custody. And in fact, the law enforcement official can take the person into custody before even applying for the warrant, hold them, because it could be an emergency where the person's doing something imminently dangerous, and hold them until the judge has had the ability to pass on the warrant. And for as long as we've had this section in the statute, and by the way, there is my memo with the proposed amendment should be on your computers.
Yes, it is. Thank you.
So, as long as we've had this section, it has had the requirement that the application be based on facts that have been personally observed. And for years, we've always thought we knew what personal observation means. It means that whoever's saying the fact or filling out the forms is the person who saw what happened. And for years, it just seemed like there was no dispute or question as to what that meant. And then in recent years, we've observed cases where that clearly has not been the case. And it's been more of a telephone kind of thing, where person A tells person B tells person C, and somewhere down the line, one person is the person filling out the application, but we don't necessarily know whether that's the person who observed it, and we don't necessarily know who the person who observed it was. And this is a serious problem because the judges who don't see the person, all they see is the application. The judges are relying on this representation that this is based on personal observation when they're considering whether to authorize the warrant. And we had a case within the last year that illustrates how seriously dangerous the current practice is, because we had a case where a woman that we've represented for years was admitted to the hospital under a warrant, and the application asserted that she had a mental illness, and the danger that she posed was that due to her mental illness, she had set a fire in her apartment, and the fire in the apartment endangered her and endangered the other people living in the apartment building. And when we got, and so the person, the warrant was applied for, it was granted by the judge, and she was then hospitalized based on those allegations. By the time we got the paperwork in my office and started investigating it, we discovered that the account of the fire caused by a client didn't even relate to our client. It was a completely different person. And yet our client was taken into custody against her will based on the story about somebody else. And we were appointed to represent her, and we continue to represent her, but that doesn't undo the fact that this client was taken into custody because of information that the judge relied on, had every reason to assume that had been personally observed by the person who was applying for the warrant. So the first proposal that of amendment that we have relates to section 7505A, and it simply says that when a warrant is filled out, or application is filled out, the person applying for the warrant must be the person who observed the behavior or the facts that give rise to the need for the warrant. So it might be a mental health screener who finds the proposed patient lying in the middle of the road, or a law enforcement officer who finds a person walking out into traffic and disregarding her personal safety. It could be anything like that, but we would know that the judge would know that the person who made that application knows for a fact that it happened because they saw it. Or if somebody else personally observed those facts, then it would need to be a written statement by the person who observed those facts. And again, very simple. The judge needs to be able to rely on the facts that are presented to him or her. And the only way to do that is if the person who observed the facts is the person who's signing this statement under the penalty of perjury, saying, this is what I saw and this is why I think it's dangerous. And so it's very important. This is, in our view, a very important change in the law.
Okay.
And we've heard from the Vermont Care Partners that, well, maybe sometimes the person can't get close enough to our client to see what they're doing. Well, if they can't get close enough, then how are they able to make a representation that they're doing something dangerous? But so that's item one.
Okay.
Item two relates to how long the warrant remains in effect. And this is a proposal to for a new section 7505E. When someone is being admitted to the hospital involuntarily, there have to be two facts that exist at the same time. One, the person must have a mental illness. Two, as a result of the mental illness, the person must be dangerous to him or herself or someone else. And they have to be dangerous at that time, at the time they're being admitted to the hospital. Usually the timing isn't really an issue But with these warrant applications, it could be that they go to the judge, they get the judge to sign the warrant, but they don't know where the person is. So as of this afternoon, Thursday afternoon, I see what this person's doing. I know that she's dangerous. Maybe they don't find her until Monday. We don't know what her condition is on Monday because we haven't seen her in 3 or 4 days. And someone who may have been acutely dangerous on Thursday may not be dangerous at all on Monday. And so our proposal is to put a time limit on the warrant so that if the person has not been taken into custody within 72 hours, then if they still think the person's dangerous, they need to come back with new current facts to justify the warrant. And those are my 2 proposals, and I'd be happy to entertain any questions you might have.
Great, thank you, Jack. Does anyone have any questions?
The only question, just a little confusion, there are 2 E's, so does the second E become an F?
Yes, it would. Yes.
Just so I understand.
Yes. So the blue on the form we're looking at from Jack is what he's suggesting we add in.
Add another E.
Okay. So Jack, thank you. I don't think we have any more questions. We will be back in touch if we do.
Great, thank you very much. I appreciate getting me in early. Now I'm off to my next court appearance. So
Well, good luck.
thank you. Yeah.
All right. Wilda, do you want to go? We'll come back to these suggestions. Let's hear what you said.
I'm sorry, I didn't hear you.
I said, I was talking to the committee. We'll come back to Jack's testimony and his suggestions, but let's hear what your testimony is. And Wilda, did you give us anything ahead of time or?
I didn't.
Okay, that's fine. No worries.
Really busy week. And I'm probably gonna partially use some PowerPoint slides. I wouldn't call it a presentation, but
Okay.
to the extent that I want to illustrate something, and I think it might be better to do so with the actual words, I might want to do that. So
Claire, can you give her sharing capability? Thank you.
Good afternoon, everybody.
Good afternoon.
My name is Wilda White, and I am the founder of an organization called Mad Freedom, which is a civil and human rights advocacy organization whose mission is to end the oppression and discrimination against people based on their perceived mental states. Marley, I'm going to ask you to go back to your pillow. Oh, good. Thank you. And that's my service animal.
I didn't even know there was I was like, who is she talking to? Sorry.
Yeah.
Can I also I'm sorry, Claire, are we good? We're not on screen. Does that matter? Okay, but thank you. Okay, sorry, Wilda. Just want to make sure we're doing the proper things.
And so I'm some of you have met, most of you I think have met me.
I think Melanie is the only one that
hasn't met me. Yeah, so by way of my background, I by education and training, I'm an attorney. Although I don't practice law in Vermont. I practiced for about 35, 40 years in California, New York, and Massachusetts. I'm also a psychiatric survivor, and I use that term to describe somebody who's been harmed by the mental health system. And I also have some experience with the procedure that is in this bill today, taking people against their will into custody, allegedly for their own protection. And I'm speaking today from that perspective primarily. I also wear another hat, and that is I was very much involved in the development of the use of force policy and the use of force law. In terms of the use of force law, I was an advocate and advocated for a provision in that law that specifically addressed interactions with people experiencing mental impairment. and I was on the group that drafted the use of force policy. And after that, I was part of the training team that trained law enforcement officers across the state of Vermont about the use of force law and the use of force policy. And I was actually the only person on that training team that attended all the trainings throughout the state of Vermont. So I'm very well aware of what's contained in that policy and what law enforcement officers were trained to do. I'm testifying in opposition to this bill. According to the bill's proponents, their intent is to make the law conform to how the practice in the field. The problem with that approach is the practice in the field is unconstitutional. And while I agree that the current statute has problems, the proposal doesn't solve or address the problems. It exacerbates them and I think basically makes them worse. I think what's wrong with this bill begins with its title. An act relating to the transport of individuals requiring psychiatric care. This statute, this part of the bill, is not about people requiring psychiatric care. This procedure is about the process we will use to determine if the person requires psychiatric care. All of the examples that have been uttered in this room have assumed that the person is a person in need of treatment. And I can tell you that is not always the case. I was sitting in my office at the University of California, Berkeley School of Law, preparing for students who were coming, who were coming basically for their first year of school. And I ran the public interest program there. I was sitting in my office on the phone and a law enforcement officer showed up at my office and said he was taking me into custody because he heard a report that I was suicidal. And when I told him I was going to finish my phone call, he told me he was going to shoot me. He threatened to shoot me, a person who was suicidal. And he did take me into custody. And I was only able to, I got myself released by acting as my own attorney. This is not a benign procedure. This is not a procedure that only applies to people who have a mental illness. People are often wrong in their assessment. And people also often have, they feel like, oh, maybe we can lie a little for this person's, good. They feel like the ends justifies the means. And so I beg you to keep in mind when you're thinking about this bill, think about someone coming to your door and knocking on your front door and saying they're taking you into custody because they received a report that you might be a danger to yourself or you might be a danger to others. Representative Peterson, you asked in the other hearing, why are we making such a big deal about transporting somebody from A to B? Well, it's a thing called the Fourth Amendment of the United States Constitution. That's why we make a big deal about it. And the Fourth Amendment says the right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. There is an exception to the warrant requirement in cases of emergencies, right? One of the emergencies is if there's a person with a mental illness who is a danger to self or others, law enforcement officers and others authorized by the state may take a person into emergency detention. However, there are strict rules that apply. And some of those rules are, and maybe at this point I will try to help you. Gets complicated, and I try to create these slides so that a layperson can understand them. We'll see if I was successful. Let's see here.
Well, can I just ask a question?
Yes.
Since unconstitutionality is not usually in our committee, and so I just want to make sure I'm understanding. Are you saying the process is not constitutional because of the Fourth Amendment? Or the Fourth Amendment is something separate in this?
The Fourth Amendment is why we're making a big deal about this.
Okay.
Okay?
Okay.
And there are exceptions to, what's showing on my slide? Yeah, okay. There are exceptions to the Fourth Amendment that says you can't arrest somebody, seize somebody without a warrant. One of those is you can do so with people who have a mental illness if they're a danger to self or others. But there are strict requirements. And those come from, it has to be based on reasonable belief that the person poses an imminent danger to themselves or others. And it must be conducted in a manner that is reasonable and minimally intrusive. That's the first requirement. Another one is you have to have an appropriate procedure. You have to give somebody due process, which usually means notice and an opportunity to be heard. And so you have to give them a hearing in a timely manner to see whether detention is justified. Also, the Equal Protection Clause means that you just can't nab a person based on having a mental illness, right? You have to have specific and articulable facts that indicate a danger to self or others. And you can't, based on stereotypes or assumptions. And just as the previous witness testified, and he was doing it in a much more gentle manner than I am. The requirement that it be based on personal knowledge is a constitutional requirement. You can't just have people willy-nilly making accusations not under oath or, double hearsay, triple hearsay, or by saying telephone tag. And finally, you have to have the least restrictive alternative. So if there are other alternatives other than this involuntary detention, they have to be considered and resorted to before this happens. So I'm going to stop sharing my screen for a second here. Did I stop sharing?
Yes.
Okay. I tell you, the technology of sharing screens is really befuddles me. So what the bill, so in light of the Constitution, the state of Vermont, in every state, creates by statute a procedure for taking people with mental illnesses who are a danger to self or others. They have a procedure that's supposed to conform to the Constitution. And Vermont has, two different routes to do this. And the bill before you discusses one of them. And there are strict requirements in that bill that must be adhered to. First of all, you can't be able to get a certificate without unreasonable delay, right? The second one is personal observation of the conduct of the person that leads you to believe the person is a person in need of treatment. And the last one is that they need to be restrained immediately or otherwise they're going to harm themselves. So all of those things have to be present before you can violate this person's right to be free from unreasonable seizures, okay? And then if all those things are present, then you're allowed to make an application for a warrant and also take the person into temporary custody. Now, one of the main problems with this bill is temporary custody is not defined. And temporary custody is a very elastic term in the law. And it needs a definition. And, one of the things I wanted to show you, and maybe I'll just go back. I want to show you the difference between when the court used the term protective custody. Am I sharing again?
Yeah.
No, yeah.
Make it bigger.
Well, I want to.
Those of us who can't. Yeah.
All right. So there's two ways. So we have in the state of Vermont a law that says law enforcement officers can take people into protective custody. It only applies if the person is inebriated. But see how the law actually defines what protective custody is? I'm looking at it like I've never seen it before. You know, and that's what this bill needs. It needs a definition of temporary custody. Particularly because temporary custody is used in this bill, not in this bill, but in this section that we're thinking of amending in two different ways. It says that law enforcement officers or mental health people can take people into temporary custody, but it also says the commissioner is holding people in temporary custody. And it's not clear to me whether those are meant to mean the same thing. I mean, there is and here I'm just gonna get sloppy here and show you there is a definition of custody in the statute, right? In another section. It means safekeeping, protection, charge, or care. That's not exactly what police officers do, right? So it's unclear whether this bill or this law means this or they mean something else. And so I think the first thing that's wrong with this bill, this law that's carried over in this bill is that the term temporary custody is not defined. Because if temporary custody means safekeeping, protection, charge, or care, that's clearly something that a mental health professional, I think that's what they say in the bill, can do. But if it means what sometimes we usually mean when we have police involved, it means depriving someone of their liberty, that's clearly something that they probably can't do. But because the term's not defined, we don't know what the legislature meant when they created this bill. So I think the first thing that needs to happen, not the first thing, but another thing that needs to happen is temporary custody needs to be defined or the words need to be changed. There was also this is an aside, but I want to address it because I think it's really important. People kept saying, oh, we don't want to use the word warrant. We don't want to use the word warrant. That means something criminal. No, warrant doesn't mean anything criminal. A warrant is a written document that gives people permission to do something they can't do lawfully without the written document. There are many types of warrants. There's bench warrants, search warrants, arrest warrants, warrants for civil commitment. Warrant is the appropriate term here. There was also a question about, well, if you take a person in and you haven't applied for the warrant, they become voluntary, do we need to apply for the warrant? And the answer you were given was no. That's not right. The warrant has nothing to do about what the warrant is the thing that authorizes the seizure of the person, right? They're subsequently agreeing to medical care. If you don't do the warrant, that seizure was unlawful. So you need to do the warrant.
So we have, actually, do you mind, we have two questions. I don't want to get too far. Hold on, Art was first and then Leslie.
My question, Chair, is more for you.
Okay.
It feels like we're delving into judiciary type.
Well, so part of it is judiciary, and I will have a conversation with Martin. But I think you're talking about other things that aren't just unconstitutional. So we want to hear that as well.
I'm not saying we shouldn't listen. I'm just saying that
yes,
you're delving into areas that aren't.
So we do have jurisdiction over this, but for the unconstitutionality part, we will connect with Martin.
I'm making the arguments before you to make the point that this needs to go to the judiciary.
Yeah.
This is not about transporting people who require psychiatric care. This is about the protecting rights of all Vermonters to make sure that they actually qualify for this transportation. I mean, there are two lawsuits, a lawsuit and a complaint pending in the state of Vermont over this particular statute where people felt that the statute wasn't followed and their rights were.
One more question. Go ahead, Leslie.
This is a clarification. Is protective custody the same thing as temporary custody?
No, and that's the point I'm trying to make. These words have no meaning unless you define them.
Okay, because I think your slide said protective and you were saying temporary or vice versa, and I got confused. I'm sorry.
Let me slow down and make the point. Okay. The statute that you have before you uses the term temporary custody.
Okay.
It doesn't define it. Okay. I wanted to illustrate how another statute that uses a similar term, protective custody, did define it. So that slide that said protective custody was shown to you for illustrative purposes only.
Okay.
To show how you might go about defining temporary custody.
Okay.
And also the necessity of defining temporary custody if you want to give it any meaning at all.
Thank you.
I hope I answered your question.
Yeah.
Okay. So, and so the other point I want to make is also connected to just the unlawful current practice. And it's when people make a warrant, an application for a warrant, there's a form on the Department of Mental Health's website that they fill out. And in that form, this is the form. Did it work?
Or you loaded a different software. It went to your browser, so you have to share the browser.
Ah.
Bobby's our technical guru. Super happy he ended up having.
There we go. Thank you very much.
My pleasure.
So here's the warrant for application found on the Department of Mental Health's website. And so even though the statute says correctly that you have to have it based on personal knowledge, but it's the practice where it's not based on personal knowledge. And the application itself, the Department of Mental Health, for some reason, says, and I'm reading here from where it says be specific. It says, state the facts that you've gathered either from one, your own personal observations, which is all the law says you can rely on. But it also says a reliable report to you by someone who personally observed the proposed patient's behavior. I mean, who's to say what's reliable? And that's usually a determination from a judge based on a sworn affidavit. And so I show you this to illustrate my point that the current practice is not adhering to the law. And we should not make the law adhere to the current practice. We should make the current practice adhere to the law. The other concern I have about this bill is something that happens in practice where law enforcement officers have told me that somebody from a mental health worker will call them up and say, hey, go pick up so-and-so. I'm going to apply for a warrant. And in the past, law enforcement officers did so, apparently. And people say that since the use of force law was passed, they're unwilling to do it anymore. And so they blame the use of force law. But I want to let you know there is nothing in the use of force law that addresses this. What happened was during the training, when we were training on the use of force law and policy, we reminded law enforcement officers of their scope of authority. And we told them that this practice of going out to pick up people without a warrant and not based on your own personal observation is beyond the scope of your authority. And so some officers stopped doing it. So it is not the use of force law that did it. It was the training that reminded them of their scope of authority.
Can I ask a clarification question? Just because I want to be clear, I'm hearing this. It wasn't a change in law. It was increasing their awareness of existing law that caused the change of practice.
Yes.
And in this case, you're pointing out to us that existing law is problematic.
Existing practice.
And existing law, both are problematic.
No, if you read the statute literally, it says that you can only pick up somebody based on your personal observations, right?
Even though it's unclear about the custody stuff?
That's a separate.
Oh, okay, my bad. All right. Yeah, all right.
No, maybe I want to make sure I'm understanding. Okay. I mean, the statute clearly says that it has to be based on personal observation.
I think I was moving to a separate thing you said, and I don't want to get us off track. So
yeah.
We can I'll let you keep going. Thank you.
It might be helpful just to just make sure we're all on the same page, and we'll just go through the.
Okay. What's clear to me, though, is that you're saying there's problems between the alignment of practice and law.
Yes.
And that people's rights are being violated potentially, or definitely. It's unclear, but it sounds like that's the issue. That's an issue.
Yeah. So I mean, these are the three requirements, right? if you want to do this procedure. The first one is in emergency circumstances where certification by a physician is not available without serious and unreasonable delay. That's the first thing. It has to be true. The second thing is true when personal observation of the conduct of a person constitutes reasonable grounds to believe that the person is a person in need of treatment. And the third thing that must be true is the person presents an immediate risk of serious injury to self or others if not restrained. And
So all three need to be true at the same time,
yes,
not one or the other.
and all three need to be true at the same time. And person in need of treatment is a term of art. And it means this. So in the field, if a law enforcement officer is alone, that law enforcement officer, this must be true. The person has to have a mental illness. Their capacity to exercise self-control, judgment, or discretion in the conduct of affairs has to be so lessened that they pose a danger of harm to himself, to herself, or others. And you can imagine how people make mistakes here, because how's a law enforcement officer supposed to know this?
That was my question.
Yeah, right? And that's some of the cases that we see where people are filed complaints are just this issue. They didn't have any information I had a mental illness.
But to further that, a professional, or a sheriff or state police or whatever, they've got to make that judgment. If they don't, because they're in fear of repercussions, and all of a sudden this person that they thought does considerable damage to others, where do you stand then? Somebody's got to make a decision.
Yes.
Immediately or close.
Yes, they have to have a reasonable decision. It has to be a reasonable basis for the decision. They don't actually have to make a decision. I mean, I'm going to go with your phrase. They actually don't have to make a decision. The statute is discretionary. It says, hey, take a person into temporary custody. But there's something here I want to illustrate here, because the person has to have a mental illness. There are many conditions that mimic some of the same signs and symptoms of a mental illness that are not a mental illness. For example, Huntington's disease, a hereditary condition where people can have psychosis. That person is not eligible to be picked up under this statute. A person who's in a diabetic emergency, hypoglycemia, they're not eligible to be picked up under this statute. The person has to have a mental illness. And so I show this to you to show that this is not, these are complex decisions that we're asking people to make.
So Wilda, there's a couple of questions, but I want to make sure you get through your testimony, and we probably only have about 5 more minutes. So, so let's let you finish, and then if there's time, and I'm sure this isn't the last conversation we'll have.
So here's a just summary of the current unlawful practice. The warrant applications are based on non-personal observations. Law enforcement officers are asked to take individuals into custody based on non-personal observations, such as upon the request of a mental health professional. And individuals are taken directly to the hospital before a warrant is issued. And that's inappropriate. One of my problems, let me stop sharing. One of my problems with this bill is that it directs law enforcement officers to take a person to the hospital, the barracks, or another safe place. And a person has a right to know where they're going. And who's to say what is a safe place? And I would argue, based on everything that I've heard, particularly in this legislative session, that the hospital is the least safe place. Given the opportunities to catch infections, I was on S36 hearing about all the violence that's occurring in hospitals. And a person who's been picked up on one of these things has not been adjudicated a patient. They're still sane until be proven otherwise, I guess we'll say, right? And they should not be taken to a hospital. They should be taken to a police barrack. And to treat a person who has not had a certificate of examination issued the same as a person that has a certificate of examination issued is, I think, to violate their constitutional rights, to be free from these seizures without following the explicit procedures of the law. What I suggest that happens on this bill is that it definitely needs to go to the Judiciary Committee. I suggest that the whole bill needs to be reexamined, and the practices in the field need to be reexamined. And I think it's an appropriate bill for, kind of a study committee, and then coming back and redrafting the entire bill and defining terms like temporary custody. And people, I watched the body-worn camera footage of somebody being taken into custody under this. And they weren't even told why they were being taken. They were just told we have to. And so there needs to be something in this bill that gives people the right to know under what authority they are being seized. And so I suggest that we, convene a study committee, that we incorporate, we make clear that it needs to be based on personal observations. We define temporary custody, and we fix all the other problems with the bill. That's my abbreviated testimony in the last 5 minutes. So I'm sorry if it was fast and passionate and organized, but
summarizing it was great because that's what I was going to ask you to do. So thank you for that. Brian?
Well, you answered some of it, so I just want to look at what I wrote so that I'm not repetitive. Because I think you spoke to what if there was a medical condition, and I guess the other questions I was have, and I think maybe you did speak to this, is like, how do people determine if it's, well, I guess here's the question. It says mental illness there. Does that mean any condition in the DSM-5?
yes.
So then someone under the influence of substances who has a substance use disorder would qualify, but if they don't have a substance use disorder, but it's the first time they ever took a substance and they're incapacitated, they wouldn't qualify? You know what I'm saying? Like, it's like tricky. This is like kind of stuff.
I mean, it's like, qualified means what the judge is going to do, right?
Yeah.
But in that case, we have protective custody. So the law enforcement officer could use either.
Yeah.
They can use protective custody because of inebriation.
And
they can use temporary custody and apply for a warrant.
Yeah. And then that leads to a second question I just want to confirm, which is that a law enforcement officer can detain someone if their behavior is breaking the law, regardless of mental health. So if they're like engaging in a way that's endangering the public and the law enforcement officer doesn't know why, they can detain them and then try to assess that, right? Like they could, okay.
Yeah.
All right. And I will say from experience that crisis will get called and police will say, we have a person in our custody and we don't know what's going on. Can you come down here and see them? And then we say, are they consenting to being seen by us? And then often that's negotiated, but I'm just trying to piece it all together, and I hear your point on all this, and I do think we need to not just pass this without further deliberation. So thanks.
Great. Thank you, Wilda.
Thank you.
Your time.
Appreciate your listening.
Thank you. Excellent.
So next week, Roger, I'm going to say it wrong, Marcoux, the sheriff from Lamoille County, Vermont Sheriff's Association. So the last part of the proposal in the bill is that a law enforcement vehicle shall have soft restraints available for use as a first option. So we thought it might be helpful to understand what soft restraints are.
Good afternoon, everybody. Again, my name is Roger Marcoux, and I'm the Lamoille County Sheriff. And I've been a sheriff for 22 years and been in law enforcement for 42 years.
Hi, Sheriff.
And somehow I got on some list demonstrated this for the Senate the day that we had the power outage.
Oh, right.
I was in the middle of a 5-minute presentation that lasted like 2 hours.
Well, and earlier we had a fire here.
I heard that, yeah.
Good thing you weren't here then.
So I'm going to show you these, but I will say this, that probably 10 or 12 years ago, I was approached by the Commissioner of Mental Health, and he was complaining that law enforcement, vis-a-vis their training, have to handcuff people under in the custody of the mental health commissioner. And they're done with hard handcuffs, and we all know what those look like.
Okay.
So we came up with a training program. It was Maureen Fox at the time and some other folks. And we developed a program in which our department was willing to try transporting people without any restraints if they fit certain criteria, no past filing. So in the state, we went from 13% of the time where people were not transported handcuffed to 96% of the time. So I'm going to show you these, but our first option is to not use handcuffs because the vast majority folks under, there's a stigma and they know what's going on. You talk to them just like you do, anybody. Anyways, so having said that, these are very, very much like seat belts, and this is not going to take very long, but they use the same handcuff key that we use on regular traditional handcuffs. And then you just unlock them and you open it like that. And the first thing that we do, and I thought I was going to be clever and ask for a volunteer, but I won't.
I was just going to say, volunteer.
I'll
Daisy said it. Daisy, exactly. Daisy said it first.
Okay, so.
I'm wearing a dress.
Okay.
I hope that doesn't make any sense.
Okay, so the object here is to put a belt, oh boy, we're on video.
Oh, you are on video because you're on YouTube.
It's not.
It's not a video.
So the sheriffs are having a terribly hard time right now, so. All right, so we want this belt to go around and then there's some restraints right here where your hands go so that it restricts your movement. What is used in traditional circumstances either is a leather belt or even a chain in which handcuffs are then attached to that and your hands are attached to that. So this is, if you're sitting in a car for a transport, it's very, very uncomfortable. And the majority of the long-range transports that we do are from northern part of Vermont down to Brattleboro or someplace. So it's a long, long trip. The other thing is that sometimes we'll bring somebody to their dentist that they've had all their life or their doctor or something like that. So there needs to be there always needs to be dignity involved. And even these, I don't care for it. But
And these are considered soft?
these are soft. They're made out of seatbelt material.
Okay.
I'll pass these around. These are just for
really
English.
I was picturing sheepskin.
All right.
I know, Paul.
I'm gonna put We're gonna
Is this how, in the field,
Yeah, in the field, I
do
would
you
ask.
describe it to someone?
Yes, and I'd ask you to put your hands on top of your head so that, when we get violent situations, that somebody's not trying to reach for an officer's gun or anything
Sure.
like that, So I've got to make some adjustments here because who knows when the last time we used these. Oh, might not be able to get them open.
Or off.
Okay, first of all, the belt goes around and these here are going to be right in front. So I'm going to go around you and I'm going to ask you to put your hands on top of your head. And I'm just going to reach around you and I'm going to explain everything that's going on as it's going on.
Yeah, this seems,
How do you do this with a person who's not cooperating?
Well, that's
They use the real thing.
that's our life.
That's the
Yeah,
whole
that's what I'm
point, right?
picturing.
Resist, Daisy, resist.
Probably, if they do resist it, the real ones come out.
And
Go
so
ahead.
you would be doing this by yourself, or would there be
Usually I'd have
more
a-
than one professional?
Well, you might,
professional?
if you're working, I'll just give you a rest here. You can put your hands down.
Yeah, it was like, you don't need that. It's like, give me my hand back yesterday.
Spin them around, make sure they're there. I'm gonna go like that, and then we're gonna click this in.
No, you're not.
No, you're not.
Feisty.
sorry, can't control them.
So anyways, and that's gonna click in. And, wait, it's gonna be a hard time.
I'd like to offer some testimony on the stocks and strengths if there's time in another day.
Okay, so now, I'll put your hands in there. Again, same thing here. And I'm basically gonna tighten these up. This one up. Anyways, I'm not gonna go through the whole
Yeah.
thing, but
Yeah.
that's the idea. That's the idea. And,
Where does that piece go?
those go on the ankles if necessary. Sometimes we get individuals that come in the car and kick out the windows and things like that, so.
Yeah, I'd
Put
do
it
that
on
if
or-
I was being,
What's that?
I'd do that if I was being taken.
Yeah.
somewhere I didn't want to go.
I gathered that. Okay.
That's
so
interesting. Just, it was definitely not what I envisioned, so I'm glad we did this.
Yeah.
Thank you.
So can I have a question on you gave a statistic 96%. Is that just Lamoille County data or is
And
that?
it's very old because years ago, and this committee will probably know, not too long ago, the CMS regulations prevented law enforcement from being in hospital emergency departments. There's only two circumstances that they can be there, and that's if a law enforcement officer brings somebody in for treatment, or if there's somebody, the hospital calls law enforcement into, for a violation of law, somebody, having a difficult time, being violent or what have you. What we were doing with this program is initially, it was just for transportation people. With Irene hitting and Waterbury being out of the picture, it began to be warehousing of people in these hospital emergency rooms. So then we were asked, all over the state, we would go and we worked with Windham County down south. We'd go to the emergency rooms and sometimes we'd stay there for 2 weeks so that people wouldn't be restrained for the protection of them and the staff. So, and that program eventually, when CMS came out with their rules, I mean, we've been doing it for 8 or 9 years, and then all of a sudden,
You
I
can't.
guess they caught on.
Yeah.
So, that's pretty much it.
Okay.
Soft restraints.
Anyone have any questions?
What was the name of the program that you and Fox were working on?
It was, I don't know there was a name for it. We just had a contract with Department of Health, or Department of Mental Health. And it was us, Windham County Sheriff's Department, and a few others that were willing to do this, just to provide secure, unrestrained security. So.
And you referred to like 98 or 96?
No, it was in the mid 90s. My recollection was 96, but maybe it was 95 or whatever. But Mary Moulton, I don't know if
Yeah.
she was, I think, the interim commissioner at the time. So I worked with her, Fox, to put this training together. And they certainly, if it's of interest to you, they certainly would have more.
And we have Morning Fox coming in tomorrow.
Yeah. So.
Can you take a couple more questions? You okay?
Oh, sure.
Art and then Alan?
Yeah, so the other 4% have those on. The 96 have nothing, and the 4% wear that.
Could be, or it could be hard restraints.
Okay.
What our experience is that we had some people that knew their situation that asked to be restrained
Okay.
because they knew they had trigger points and things that I didn't understand. But it was an education that I think all law enforcement should have, because it really caused you to, if you were going to spend time with somebody, to try to understand their situation and the stigma, around everything. And just remember that you want to treat people the same way as a law enforcement officer that you would want your mother, your sister, your brother, whatever treated.
Okay. Alan?
Little different question, but you're up in my area. So how many times do your sheriff department has to go to Brattleboro under these conditions? Or just close? Is it a lot or?
Twice a week.
Really? Okay.
And that's just my department.
Yeah.
Yeah. So, and it's really difficult to ask somebody to go for 2.5 hours, whatever it takes to get down there. I wish we could find a closer solution in this area. So.
You too. Yeah. Great. Thank you very much.
Thank you.
I appreciate it.
Thank you.
Builder, we have like 5 minutes if you want it on this.
Good luck
Or you can
tomorrow.
come back.
Yeah, thank you. Well, here.
Thank you.
Here with it.
Yes, good seeing you.
Wilda White again. You know, on this mechanical versus soft, I think that the soft restraint demonstration I just saw would be actually more upsetting to a person in this situation, given its unfamiliarity and it's more invasive across the body. And I think they would think that this was something that was happening to them because they were perceived to have a mental illness. And so they would already feel triggered by that. And so, you know, I've been handcuffed before. And for me, I think the issue is how tightly those handcuffs are on. So this officer put handcuffs on me, and they were so loose that when he said I'm free to go, I just took them off and handed them back to him. And so I think that these what we're calling hard restraints can be fine because people are more familiar with it because what they're really upset about is the loss of their liberty, and it's not, you know, how they're restrained is like almost like asking someone to pick the color of their jail cell. It's just really not a big issue. And I think the mechanical restraints would actually be better.
Okay, thank you very much. So we have a lot to come back to here, and we will. And I will talk to the chair of judiciary. Let's take a 5-minute break, and then we're gonna try and finish up pretty quickly on S37 and section 9.